My name is Noor Hanady. I'm the Registrar of the DIFC Courts. We've got three very esteemed panelists joining us today on the future of remote hearings. So I will introduce them in turn and then we'll get started on the questions. So first of all, pardon me, we've got Janet Clark. Janet is a social researcher working in the user experience and insight team within Her Majesty's Court and Tribunal Services, which is the HMCTS in the UK. Janet has recently led on a large-scale evaluation on the use of remote hearings in UK courts and tribunals during the COVID-19 pandemic. Janet has an MA in Social Research and Evaluation and a Masters of Science in Developmental Studies. Prior to joining the HMCTS, Janet worked on research and evaluation studies across health, social care and international development, including health-focused projects with prisoners and ex-offenders in Lesotho, Eswatini, Malawi, Zambia and Zimbabwe. So thank you very much for joining us today, Janet. Second, we've got Mark Mclaughlin. Dr. Mark Mclaughlin is a Global Visiting Assistant Professor at Singapore Management University and the Singapore International Dispute Resolution Academy, SIDRA. Dr. Mclaughlin has been involved in training government officials around the world in managing their investment treaty commitments and navigating investor-state disputes. He has given talks at events organised by Singapore's Ministry of Law and the United Nations Commission on International Trade Law. His research on international economic law and dispute resolution has appeared in leading international journals published by the Oxford University Press. In particular, Dr. Mclaughlin's expertise focuses on state-owned enterprises, investor-state mediation, and emerging technologies. Dr. Mclaughlin's current area of focus is the interaction of international investment law with artificial intelligence. Welcome, Dr. Mclaughlin. And last but not least, we have Zoe O'Sullivan QC, who is a barrister and arbitrator practicing at Searle Court in London. She is a Part 2 registered DIFC Courts practitioner and regularly appears in the DIFC Court as counsel. Her subject matter expertise includes banking and finance, freezing injunctions and asset recovery, jurisdictional disputes, shareholder disputes, oil and gas, commodities, and IT outsourcing disputes. Zoe also regularly sits as an arbitrator and has been appointed as presiding arbitrator, sole arbitrator, and co-arbitrator in the LCIA, ICC, and UNCITRAL commercial arbitrations. Welcome, Zoe. So thank you very much again for joining us. Mark is based in Singapore. Janet and Zoe are based in the UK, so very early for them. So what I'll start off with, I think, is a fairly broad question. I'd like to go around in turn, starting off with Janet, please, then moving on to Mark and finally Zoe. If everyone could please tell us about their experience to date with remote hearings. So over to you, Janet. Thank you.
Thanks, Noor. Yeah, so as you mentioned in my introduction, I led on an evaluation of remote hearings, which came about during the pandemic. So pre-pandemic, HMCTS had begun to develop a bespoke platform for remote hearings, which was part of the reform programme, which aims to transform and modernise the justice system by 2023. And then when the UK went into its first lockdown in March 2020, there was a swift transition to the use of remote and video hearings. But the bespoke platform that was being developed was not developed enough to be able to be rolled out across all of the courts. So as a result of that, a variety of platforms were used, things like Zoom and Skype, as well as Teams, and also cloud video platform, which was an off-the-peg platform, which was adapted for courts and tribunals in the UK. And under normal circumstances, we would have piloted the rollout of a platform like this and tested it in phases. But obviously the pandemic created this slightly strange situation where it was being rolled out at extensively. And so a decision was made to carry out a process evaluation so that we could use the lessons from this unplanned and rather unusual situation to kind of to think about how to take things forward in the future.
Speaking of remote hearings, I have to remember to unmute myself, which is something you don't have to do in a face-to-face panel. That's very helpful. Thank you so much, Janet. I think the DIFC court experience was very much the same. All of the infrastructure was in place, but then it was putting everything into practice, which was quite a challenge. So thank you very much for that input. Mark, over to you, please, on your experience with remote hearings. Thank you.
Well, thank you, and good morning and good afternoon to everyone joining us wherever you are in the world. My background is in investor-state disputes, so the circumstances in which a foreign investor wants to sue its host government because it's believed it's been treated unfairly, inequitably, or has somehow been discriminated against. The dispute resolution clauses in investment treaties allow investors to take those disputes to arbitration and increasingly mediation, and that's my area of research. So I'm part of a team at the Singapore International Dispute Resolution Academy, which we call SIDRA for short. And for the past few years, we've been conducting a survey on cross-border dispute resolution, so normally commercial disputes. And our survey deals with litigation, arbitration, and mediation, and also kind of mixed mode or hybrid processes. So as part of that study, we've asked legal and client users of these different processes about the use of technology in these disputes. Now, as I've said, the SIDRA survey targets client users. They're made up of corporate executives or in-house counsel, and legal users, so external lawyers and legal advisors of different dispute resolution processes. And it's kind of the findings of this survey specifically to do with remote hearings that I hope to be able to share with you today. So thank you very much for the invitation. I look forward to hearing from the rest of the panel.
Thank you so much, Mark. Very, very niche areas there, which we look forward to hearing about in more detail. Zoe, I think your experience with remote hearings is self-explanatory because you sit as a barrister. You are a barrister, and you also sit as an arbitrator on many arbitrations. But over to you for a high-level and detailed discussion on how you have found remote hearings so far. Thank you.
Okay, so good morning from a sunny but somewhat chilly London. Yes, I suppose I'm the voice of the user experience here, and I'm a good subject for trial because I'm not particularly tech friendly, as anyone seeing me this morning on this call can testify, and yet I've made it work. So I had to do a very large number of online hearings as a consequence of the pandemic, both as counsel and as arbitrator. So I can also testify from the perspective of the bench. I think at one point I did 7 back-to-back arbitration hearings online in 2020. So it was a very steep learning curve. But the applications and the hearings I did involved a whole variety of things. They involved, for example, urgent interim applications as counsel, such as obtaining a freezing order, or interim applications where there were only lawyers present, such as arguments about disclosure, or applications for summary judgment. And then at the other end of the scale, full-on hearings with witnesses of fact, experts, where every single person was on a different machine. So it's quite a variety. And I have to say that on the whole, the experience has been very positive. And I found that I and everybody involved managed to adapt pretty quickly to the challenges of moving online. So on the plus side, and I'm sure you all got your own wish list, but of course the huge benefit is not having to travel for hearings. The convenience and flexibility, it just saves me as counsel an enormous amount of time and effort. And of course it saves the client a fortune, particularly from the perspective of someone who's a DIFC practitioner who's based in London. And of course, there are the eco benefits as well, and not adding to the carbon dioxide cloud. And of course, it's much easier to make yourself available for hearings at short notice. I mean, forget hearings. I mean, I can speak to my solicitors online, very short notice, and we can all see each other, and it's tremendous. And I would say that the one is very dependent on a good third-party provider to supply the platform for the hearing, but those providers have proved to be very adept and very helpful. I mean, that does come at a cost, and I'll come to that when I come to the downside. Many features, the mute button, who knew? It's very useful at limiting interruptions by your opponent, which is wonderful. So in some ways, it enforces courtesy because everyone has to wait for their turn and formally unmute. When it comes to cross-examination, I suppose that is the big one. I was concerned that it would not be as effective. As it turns out, I think cross-examining by Zoom is much better than it was on the old technology. I mean, it seems like a past age, but you know, in international practice, I've often had calls to cross-examine witnesses on VCR, but they were on some enormous screen at the far end of a large room, and it was not all satisfactory, and there were often technical problems. So I think it's better than that. I have some reservations about how effective it is, but on the whole, I think it's perhaps not the ideal solution, but it is a workable solution. Certainly, I haven't experienced any challenges to, for example, arbitration awards on the grounds that the procedure was not a fair one because the witness was giving evidence online. So that's quite significant. Downside, I'd say the main downside is what you might call the human factor. I mean, watching a football match on TV is quite different from experiencing it in person. And it's absorbing all the body language, the non-verbal cues that enable you to have to monitor what's going on, to read the tribunal, to read your opponent. And then there's the ease of interacting with your team, in my case, my junior. It lacks that immediacy. You feel that you're one removed from everything. And I think particularly when it comes to interactions with the tribunal, picking up perhaps their irritation or the points they're keen on or not keen on, or whether they're bored, I think this can be a real challenge. Especially, I mean, imagine, you're not in a room with someone, they're in a tiny little box at the bottom of your screen, and it's really very difficult. And speaking as an arbitrator, sometimes you want to ask a question and counsel haven't noticed. I've literally been reduced to putting my hand up and saying, like this, and then eventually someone sort of digs their elbow into counsel's side and counsel stops. So, I think that's a new etiquette we all have to get used to. Technical issues invariably arise. I mean, I didn't do a single hearing where we didn't have some connectivity issue at some point. I generally act for well-resourced parties with technical support, and all these problems were addressed. One particularly amusing instance late last year when I was appearing in a hearing before Justice Martin in the DIFC court, and we had a break, and then we came back and we were in somebody else's hearing, and there was a lot of, "What are you doing in my hearing?" But it was rapidly sorted out with the excellent technical support from the DIFC court. So that was slightly entertaining, but not fatal. There can be real fairness issues if there's unequal access to technology. But as I say, that hasn't actually proved to be a terminal issue in any of the cases I've done. And of course, there's the famous Zoom fatigue. I'll say Zoom because it's the best known of the platforms and frankly, my favorite. But we've all experienced it. And there's been research into the psychology of Zoom fatigue, the fact that you're concentrating on a small space, that you're having to work extra hard because you're not able to pick up the body language in the same way. I mean, we all have experienced it. It can be exhausting. It makes long periods of concentration very difficult. And so you need to build in more breaks, which in turn means that you have to have longer hearings. I mean, might even extend a long hearing by a day or so, just to allow for the extra breaks and for the fact that people just cannot keep going as long. So that all adds to the expense. And time differences, of course, is another one. I mean, today we've all got relatively civilized time differences. And I have to say the Australian-based judges in the DIFC court have made themselves extraordinarily available. Obviously, there are huge time differences when you're in Australia, and on the whole, they've come forward to meet the parties by being the ones to take one for the team, sit late or sit early. But that again can cause cost problems if you've got witnesses in far-flung jurisdictions. They have to be accommodated. You end up with a much more disjointed and prolonged hearing than you might otherwise have done. You all have had your own experiences. On my position, it's not perhaps ideal in every respect, but I've been really very pleasantly surprised about how positive the experience has been.
Wonderful. Yes, I think lawyers, we do tend to be creatures of habit, and our habit, unfortunately, for many, many years is to use, for example, paper bundles when we're preparing for hearings. And we love the human experience because we do tend to be very sociable creatures. So I think there has been a very quick change in sentiment in amongst the profession. So I look forward to exploring those challenges and advantages with you in further detail later on in the session, Zoe. So thank you so much for your input. I think we'll move back to Janet now, and we'll focus on her research, which was extraordinary. So Janet, based on your research conducted for the Ministry of Justice, could you please share with us some of your findings on what people in the UK have said about remote hearings? Obviously, we've heard one opinion from Zoe, which was super helpful. And I think that largely lots of people might share that same sentiment of not wanting, not liking remote hearings, and then warming up to the idea on the basis that you're doing a lot more with a lot more limited time. But I understand that your research was kind of tailored towards people who worked both in the criminal field and commercial. So not necessarily lawyers only, it was also targeted at litigants. So it would be wonderful if you could give us some context on who the relevant surveys went out to, what the research findings were, etc. Thank you.
Okay, sure. So I'll start just by giving a bit of context. As you mentioned, the evaluation was cross-jurisdictional, so it encompassed crime, civil, family, and tribunals. Not all tribunals were fully encompassed, but we have quite a wide range included in the study. We used a large-scale public user survey, so we have views from just under 5,000 public users, and that included both people joining remotely during the pandemic and people attending in-person hearings during the pandemic. We also surveyed the judiciary, legal representatives, and HMCTS staff. And then in addition to that, we carried out 180 in-depth interviews. So around half of those were with public users, but we also interviewed judges, magistrates, legal representatives, HMCTS staff, observers, and support professionals and intermediaries as well. So we tried to get as broad a picture as possible, which means that when we make generalizations, we have to be a little bit cautious because obviously in different jurisdictions and with different groups, there might be quite a lot of variety. But one of the things we found was that remote hearings varied considerably in how they were used. So in some of the some cases, the decision to use a remote hearing in some jurisdictions was cross-jurisdictional. So there was an approach and a general use of remote hearings, whereas in other jurisdictions it was much more case by case with judges making decisions. And what we found was they were much more widely used in tribunals and family courts, and less in the criminal courts, which wasn't a great surprise. Perhaps a more surprising finding was that public users that attended remotely were more likely to be satisfied with the overall experience of their hearing compared to those who attended in person. And satisfaction was higher amongst those joining by video compared to those joining by audio. And satisfaction of public users kind of echoes many of the things that Zoe said, really. It's about convenience, reduction in travel time, reduction in costs. They also felt that reduction in formality was a positive thing for public users. Also, not having to be in the same room as the other party was seen as a real advantage. And all of those things led to satisfaction for public users. Then, looking at the professionals, legal representatives were much more in favour of remote hearings than judges and HMCTS staff. And public users attending a remote hearing were more likely to agree that they could express their views and that their views were considered, which is another slightly surprising finding, I think. And we asked about perceptions of effectiveness and fairness of the hearing, and there was no difference between the group attending remotely and those in person. And then another quite interesting finding, we asked people, all the different groups, about how they felt about the appropriateness of remote hearings, both during the pandemic and also for future use beyond the pandemic. And 2/3 of public users felt that remote hearings were acceptable during the pandemic, and just over half said that they felt it would be acceptable beyond the pandemic. And then with professionals, there was a very high proportion of all professionals felt that the use of remote hearings was appropriate during the pandemic, but with legal reps being much more positive than HMCTS staff and the judiciary, thinking about future use of remote hearings. And then I'll just say a little bit about some of the challenges, because it wasn't all wonderful. So not surprisingly, there were quite a lot of challenges. One of the big issues was the technical problems that people had. So 1 in 5 public users attending a remote hearing said that they had issue with technology. That was highest amongst those attending by video, less so with audio hearings. Main issues were inconsistent audio quality and people getting disconnected. And this was resulting in hearings taking longer, as Zoe's mentioned. It was also harder for public users to contribute and to follow their hearing, and they were less likely to understand the outcome where there were technical issues, which is quite an important point, I think. Another challenge was communication. Where public users were represented by a legal representative and they were attending remotely, they were less likely to find it easy to communicate during the hearing. And there were particular challenges amongst vulnerable users, public users. So the rate of challenge with communication with the legal rep was a lot higher for those public users that identified as vulnerable. And then we also looked at it working with interpreters in remote hearings and identified quite a lot of challenges with the use of interpreters. Some of those things we've tried to start to address, but obviously that was quite a significant issue during the pandemic. They were not always visible to the client and not always audible, and there were all sorts of issues with the interpreter having not been able to pin and control what they could see. And then lack of information about delays and cancellations was another issue that was raised with remote hearings, and how the legal representatives, for example, talked about how this created lots of stress for their clients. And then we asked about questions about health and well-being for professionals, and 3 in 5 judges felt that remote hearings impacted on their health. So they talked about increased fatigue, which was the most common issue, increased stress, increased workload, fewer breaks, and just over half of legal representatives said that they felt remote hearings impacted on their health and well-being. They liked the fact that there was reduced travel, but said that they found them more tiring, and they missed the interaction of the court, and also commented that work-life boundaries were more challenging when working with remote hearings. And then we asked the same question of HMCTS staff, and they were least likely to report an impact on health and well-being, although they did talk about increased workload. Would it be helpful to say a little bit more about some of the things that we found contributed to an acceptable, effective hearing? I'm just conscious of time, so it's quite a long.
I think you've got a couple of minutes, so yes,
okay,
please.
Sure. Yeah, so we looked at what factors facilitated effective hearings, and one of the things was effective guidance and information pre-hearing, so making sure that people were aware of what to expect before the hearing, and making sure that they had links and all the information they needed in good time, ensuring that vulnerable users were aware of any support or adjustments that they could request ahead of the hearing. Where there were interpreters, it's important to provide an opportunity for the interpreter to familiarise themselves with the person that they're interpreting for, particularly important for sign language interpreters, because they need to check that they have the right language, because sometimes the person might not be speaking British Sign Language, for example, they might be speaking a different sign language, and to understand their communication style. And then communication during the hearing. For public users that only had access to one device, that seemed to be a really significant challenge. And also where the public users had discussed with their legal representative how they would communicate during the hearing, ahead of the hearing, that was also quite important. But obviously you can't WhatsApp somebody during the hearing if you're actually in the hearing on your phone and you don't have access to another device. So that was another challenge for some of the public users that were attending, not for professionals, but for public users. So I've probably stopped there because I know other people have got lots to say. So
wonderful, that's so helpful. Thank you, Janet. I think you mentioned a very interesting comment about the vulnerable. And I would probably classify some of our small claims tribunal litigants as being in that vulnerable category. And we certainly did see some decrease in the number of small claim tribunal cases that were registered during the duration of the pandemic initially. And it may have been the case that people didn't have the relevant technology to be able to log into remote hearings and get the support that they needed, or they didn't know how to do it, and that would deter them from filing a case with the courts. Whereas, for example, in the court of first instance for us, we had more registrations than any other year during the pandemic, during particularly the lockdown period. So I think now that the Small Claims Tribunal has decided to completely shift across to remote hearings and is conducting the relevant training and cluing people in with the relevant information and guiding them on how to access the remote hearing, we're seeing a steady increase again in those cases. But that was a very interesting observation, I think, that came out of your survey. So thank you very much. Mark, I'm going to pick on you now. So as I understand, your research sample was broader than Janet's because your study was based on cross-border disputes, not limited to litigation. So it addressed all forms of dispute resolution, ADR. And the respondent input was taken from all over the world, but you did mention to me privately that most responses came from people based in Asia. Also, your research targeted those involved in investor-state disputes, as you've highlighted earlier. Would you please share some of your findings with us? And I'm curious to see if there's any differences in your findings versus Janet's.
Yeah, well, specifically, there's lots of overlap, I think, and the findings reflect lots of what Zoe has said and what Janet has said. So I think there'll be some synergy certainly between us. So the CIDRA survey targeted responses of client users, so made up of corporate executives, in-house counsel, and legal users, so lawyers and external advisors, of cross-border dispute resolution processes. So we got responses from 46 countries, but primarily the responses are from Asia and specifically Singapore. And the survey covered, as you've mentioned, litigation, arbitration, mediation, and mixed mode and hybrid processes. And they do include more than just states. In fact, most of the respondents were involved in commercial disputes rather than just investor-state disputes. So the underlying goal of the survey was to understand why users of dispute resolution make the choices that they do. Why do they choose one process over another? And as part of that, we had questions about the use of technology and the use of technology in these cross-border disputes. So as a starting point, I think there are some headline figures when it comes to our findings on remote hearings specifically and the use of technology generally. Firstly, the support for the usefulness of conducting virtual or online hearings is consistently high across all forms of dispute resolution. So this reflects much of what Zoe has said. So litigation, arbitration, and mediation. So in our survey, at least 78% of all users of these processes answered that remote hearings were useful or extremely useful. So if there's anything to indicate a kind of our future direction of travel, that would certainly be a good factor to bear in mind, and that legal and client users are expressing confidence in the system. Now, I think what's really interesting is those numbers pre-pandemic and now, whether you want to call that kind of mid-pandemic or post-pandemic, depending on how optimistic you might be. So we had no idea that when we launched the survey that we would have pre-pandemic and post-pandemic numbers, because it was unbeknownst to us that the pandemic, of course, would happen. So when we released the findings of the first survey in 2020, support for the use of technology and more specifically online platforms didn't break the 50% mark. So for arbitration, the use of online platforms had support about 47% of users, mediation 35%, and litigation 34%. So when you compare those numbers to now, which is 78%, as I mentioned earlier, so the support of online platforms has almost doubled, or even more than doubled, in the past 2 years. Now, behind that 78% figure, there are some nuances. So most notably, I think, remote hearings or online proceedings are regarded as less useful in mediation than they are in litigation or arbitration. So for litigation and arbitration, that 78% number jumps to 86 and 89%. Now that might reveal that users believe, particularly in a mediation proceeding, that that in-person connection where you're attempting to reach a settlement is more important than in an adversarial process where that resolution is going to be imposed by a third party. So I think with mediation where you need agreement from the parties, you need them to get over their differences, legal and client users consider that in-person connection to be more important than in other forms of dispute resolution. But nevertheless, despite that small bit of nuance, support for remote hearings is consistently high. And in my view, this can be explained by a few factors. The first, it was obviously born of necessity, right? So we weren't able to conduct virtual hearings, and all of us have mentioned this, because of lockdowns and travel restrictions. And so clients and lawyers had no choice. They had to conduct business and hearings remotely. But I think what that has done, and I think this reflects much of what Zoe has said, is to create a kind of new generation of legal and business professionals who are now familiar with online platforms, familiar with how to present a case remotely, and some of the technical issues that might arise. Because of course, technical issues also happen in person. You know, you have lawyers, they forget a document, it's not been printed properly, all of that kind of stuff. Just because technical issues happen online doesn't also mean they happen in person. And so I think this additional or new familiarity is breeding and increased confidence in remote hearings and creating this sense that they are legitimate for dispute resolution processes, whereas they weren't before. One of the most prominent responses we received, perhaps unsurprisingly, when we asked what factors would make you choose a wholly online platform, for example, over an in-person hearing. So in other words, what are the factors driving this growth and driving this increased confidence? And one of the most prominent responses we received was, of course, travel restrictions. There's a consistent finding across legal and client users and across different types of dispute resolution. And so as with support with online platforms generally, the relevance of travel restrictions was slightly lower for mediation, reflecting what I said before about online hearings maybe not being optimal for mediation proceedings or not being considered as optimal. But nevertheless, still around 60% of mediation users considered travel restrictions to be an influential factor in choosing a wholly online process. But aside from travel restrictions, because of course travel restrictions will at some point be lifted now, we hope at some point. So some common factors chosen by respondents as to why they would choose an online hearing was that the value of the dispute was low, that the case was of low complexity, and that the costs of a remote hearing were low. So these are some of the important factors that led users to choose a wholly online process. But there are some kind of interesting nuances underlying our findings in these areas. So firstly, that this was not consistent across all forms of dispute resolution. For example, lower costs of the process was far more important for mediation and litigation than it was for users of arbitration. that's maybe used to higher costs. So in other words, arbitration users were supportive of remote hearings at roughly the same rate, but for different reasons than users of mediation and litigation. So for users of arbitration, for example, the more important factors driving them to a wholly online proceeding would be the lower complexity of the case, or that the value of the dispute was lower. So another interesting discrepancy apart from between the different processes was the difference between legal users, so lawyers, and client users. So client users, obviously the business themselves, the in-house counsel, and the legal users being the external lawyers. So for client users, the fact that dispute value was low was very influential in the choice to opt for a remote hearing. So about 88% of client users said that this would be one of the reasons why they would choose a remote hearing over an in-person hearing. So the value of the dispute. So 88%. But for legal users, that was 26%. So 88 versus 26 when it's clients and lawyers. So clients and lawyers look at this issue very differently. Of course, it's ultimately the client that would end up paying the costs of the hearing and the cost of the settlement of an award. So it's perhaps unsurprising that they are more concerned with the value of the dispute. But one of the reasons why I think that may be particularly significant is that at some point travel restrictions will be lifted. And so in those circumstances, the question arises as, are we still going to be using remote hearings even when we could, in theory, meet in person? And so I think the costs and the extent to which the client will be able to drive whether it's an online or in-person hearing is going to be a significant thing in the years ahead. Because often, as you know, clients will be affected by what their lawyers say. So this discrepancy between the lawyer's view and the client's views will be an interesting one to see how it pans out. So just before I wrap up, I would summarize my kind of 4 main points of what I've discussed in the past few minutes. So firstly, that users of cross-border dispute resolution mechanisms consider remote hearings to be useful or extremely useful, which is significantly higher than pre-pandemic. Secondly, this varies amongst forms of dispute resolution. So remote hearings are considered to be less useful in mediation than they are in adversarial processes. Thirdly, factors influencing the choice of remote hearings are many of the things that Janet and Zoe mentioned. So travel restrictions, value of the dispute, cost of the hearing, complexity of the dispute, availability of witnesses was another one. And finally, that these factors are not necessarily the same for clients and for lawyers. So with that summarised, I think I'll bring my comments to the close and pass back to you. Thank you very much for listening, and I hope to hear from the rest of the panel.
Thank you so much, Mark. That's very interesting. There was discussion, I think, informal discussion, just hashing up on one of the topics that you discussed, that perhaps the future is that low-value disputes will continue to utilise remote hearing platforms, whereas higher value disputes that typically sometimes or most of the time involve, say, cross-examination of multiple witnesses, etc., might still be more amenable for in-person hearings. So I think that's probably where I think the profession kind of sees eye to eye at the moment, not just with the profession, but probably also judges. I speak from experience because I sit essentially as a judge for lots of different types of hearings. Certainly the quick hearings that we have, it's so easy to just conduct them over the phone. We can list them in a day, 2 days notice, and there's no calling of witnesses, and you achieve the exact same purpose as you would if you had an in-person hearing. In fact, it's probably a lot more with an advantage because people are typically more available at the last minute for a quick log in for an hour, log out. Whereas some of my hearings involve the calling of expert witnesses and witnesses for example, Part 50 examinations. And these types of hearings require putting a witness in the box and questioning them on various bits and pieces, basically. Some of these hearings can go up to a few days, and typically the way that you read a witness is by having that face-to-face interaction. So from my perspective, those types of hearings are certainly a lot better equipped to be face-to-face. But I only have one side of the fence. Zoe, you've got both sides because you have sat as an arbitrator, as you mentioned, and you also appear as counsel. So I'm curious to know whether you have different experiences putting your arbitrator hat on. Do you prefer face-to-face hearings? I wonder if the answer is yes, because certainly for me, I would prefer face-to-face hearings when I'm making a decision on something, like I said, something quite massive, and arbitrations these days tend to be quite complex. And you have mentioned that you've sat as a sole arbitrator and you've sat as a chairperson as well. So I do wonder if your point of view changes versus appearing as counsel on a hearing. What is your preference? Does your view stay the same? What are your comments in that regard?
Okay. Oh, that's very it's a complex picture, isn't it? I mean, the point I would make, I think, is that I'm at what you might call the luxury end of the legal profession because I tend to act for sophisticated and well-resourced clients. And also in civil cases or even in private arbitrations where it's a closed circuit, the issues that Janet has identified about access to justice, members of the public not understanding what's going on, don't really arise in my sort of practice. Okay, so for me, I suppose the dividing line is going to be between the witness action, the very complex case with witnesses and live evidence, and the cases that involve largely counsel and submissions on paper, or at least legal submissions orally without reference to live evidence. And it seems to me that the counsel-only cases work very, very well online. For example, the agility. If you want to apply very rapidly for a freezing order, I think during lockdown I got one in the DIFC court on 24 hours after being instructed, which is quite remarkable. It's partly a testimony to the willingness of the judges to make themselves available. But and there's really no reason why an interaction between a without notice applicant and a judge, or even a fully contested hearing with counsel on both sides, shouldn't work very well online. Witnesses is another matter because there is this need to evaluate. I have to say, it hasn't been as challenging as I had thought. I think simply because actually, certainly in international arbitration, we already had some history of examining witnesses remotely, and it wasn't very satisfactory, and Zoom has been better. In a sense, if your witness's face is filling the screen, it is actually possible to form some views about their credibility, their body language, and so on. So it's not, I would say it's not an ideal substitute for in-person hearing, but it worked. When we had no alternative, it did work better than I thought. Whether I suspect that is where the parties will want to draw the line going forward. I mean, there are concerns. One of the concerns that's often expressed in arbitration by the parties is if a witness is giving evidence remotely, it'll be possible to interfere with their evidence because people won't be able to see what's going on. There might be past secret messages, looking at their phones, and so on. I personally think that is exaggerated, that concern. I think it's very obvious if someone is trying to coach the witness. I mean, and there have been occasions where witnesses have sort of started looking at their phone, and then you immediately get sort of huge outbreak of suspicion on the other side, and then you have to get them to hand over their phone for looking at, and so on. And I think, frankly, the idea that anyone in full flow can be diverted from what they were going to say by coaching, I think it's an illusion, actually. But of course, you know, people are concerned, but there are perfectly sensible ways of addressing that. And you can have rules about who's in the room. You can have, if you're really suspicious, a 360-degree camera. You can pan around and show that there's no one else there except maybe an interpreter, or sometimes a party representative to help find the documents and so on. So I think that's overstated. I think at the end of the day, there is no substitute to actually seeing the witness in person. And that, I suspect, will be one of the deciding factors. And some other aspects to just reacting to what my co-speakers have said. it's interesting that Janet's survey ascertained that people will prefer the greater informality of online hearings. And I would have thought that would have been an issue actually in the criminal courts, because you can get disruptive people. On the whole, that's not generally a problem with civil hearings, although it can be. And I say that is the tendency to informality is a problem that the tribunal has to address. I mean, when we were all sitting in our bedrooms or, you know, whatever, with cats and children interrupting, and, you know, even now, frankly, you've got people pinging with Amazon deliveries and so on. So, you know, that requires, I think, that the tribunal has to set the tone there, and counsel as well, of not moving into a more sort of slangy, informal approach, which is, you know, it's important to have these boundaries. I mean, another downside, I guess, I'm moving away from the witness point, is that you do the need for expert support, which does greatly increase the cost. I mean, this is not really necessarily an online-offline issue, but I mean, we're moving towards fully electronic bundles and so on is something that's been happening for years. But you do need a document provider, which, you know, hugely increases the expense of the proceedings, although it is actually incredibly useful. And of course, you need multiple screens. So, you know, it's not necessarily a cost-friendly option. So I think possibly the idea of it saving cost is illusory. Particularly some arbitrators are a bit old-fashioned and they like paper copies of everything anyway, so query how much money you're saving in terms of copying and sending bundles. Yes, so hybrid hearings are something that I've seen. I mean, you might think that's a sort of perfect compromise. I'm not sure it is actually, because the kind of hybrid hearings I've been involved in is where you might have the tribunal and counsel in a room, but maybe the witness is giving evidence remotely. I mean, that, I'm not sure how much that adds to the party. I mean, it brings you the sort of body language cues. It's certainly easier for counsel to interact with the tribunal, but it's not really addressing the problem that you still got the witness on a screen. Anyway, but I would conclude, I think, I mean, I myself am very much in favour. I think, you know, I have some reservations. But interestingly, when I was in Dubai for Dubai Arbitration Week last November, I took part in a debate about this issue, about whether remote hearings should be the future for arbitration hearings. And I spoke against the motion. I was arguing that they shouldn't be, and I fully expected to lose. I said confidently to my opponent, "Oh, well, you're going to win this." Funnily enough, I did carry the day by a margin of something like, I think, 53 to 47, which was interesting. It shows that even sophisticated users in international arbitration still think on balance that we ought to go back to the old days. So, you know, watch this space. It's interesting.
Thank you very much. That's very helpful. I think living perhaps in this part of the world, in Dubai, where there is the hustle and bustle of you know, the big city life, people do tend to like to travel for work. They do tend to like to travel for hearings, you know, engage in some networking, kill two birds with one stone. So I do wonder if that's why the profession a lot of the time doesn't see eye to eye with the future of hearings being remote. But yes, I guess watch the space, and I wonder if the test or if the experience for arbitration will be different than the experience for litigation. Certainly the formality that we spoke about is something that litigation has that arbitration doesn't have necessarily to such a strict extent. Litigation is a very requires and calls for a very formal process, both from a procedural process to an etiquette, to a way of dress, etc. So people typically embrace that because they want the formality with litigation, whereas with arbitration they do technically like that bit of flexibility. You don't have to be robed, for example, when you're in court. But we have, as a court, we've let go of a lot of that formality. You don't have to be robed for remote hearings anymore, which is, you know, great, because the robe does tend to get very warm when you're wearing a suit. in 40-degree heat. Yes, we are in an air-conditioned facility, but when you're speaking, when you're on the spot, you do tend to get flustered and your body temperature does go up. So it's very much welcomed, I think, the fact that you don't need to robe up anymore. So very, very helpful insights there. Thank you. This question was prompted by my discussions with Janet. So Janet, again, I'll start off with you. And Mark and Zoe, I appreciate that you might not have too much to say on this question, but we'll start off with Zoe and we'll see if you've got any comments to follow. Sorry, we'll start off with Janet and see if you've got any comments to follow. So Janet, based on your research and experience, was there any observed behavioural changes during remote hearings as compared to in-person hearings?
Yeah, sure. So we asked professionals about their perceptions of behaviour change in remote hearings, and a reduction in formality was the most significant observation across all the professional groups that we spoke to. There was also perceived levels, reduced levels of concentration and reduced levels of respect were also reported. And then punctuality was not considered to be very different between the two groups. People tended to be arriving punctually to the hearings for both categories. There were some differences between the different professional groups though. So legal representatives were much less likely to perceive changes in behaviour and attitudes compared to the judges and also HMCTS staff. The figures were quite significant. So 37% of legal representatives felt that there were differences, but 69% of the judiciary. So the figures were very different. And around half of judges felt that remote hearings were effective at creating a comparable environment to an in-person hearing, but 4 in 10 thought that they didn't do that very effectively. And public users attending by video were more likely to find that they felt that their hearing was formal and official compared to those attending by audio. So of those attending by video, 84% felt that the hearing felt official and formal, and 79% of those attending by audio. So there is quite a difference, I think, in experiences between audio and video, which is also worth exploring, I think, thinking about the future.
Thank you, that's helpful. Certainly I've experienced people, usually when you've got an in-person hearing, people are never late because the hearing is listed, for example, at 10 o'clock in the morning. You expect everyone to be assembled, ready to go at 10, which is when the court orderly calls the list and we get started. But I have seen for remote hearings, I had a hearing last week and someone casually showed up 20 minutes late with no excuse, no good excuse. So I did not look on that very favourably, and I think I had to have quite stern word to say that just because we're in a remote hearing does not mean that you are tardy. You still need to be on time. The court still has a list to get through. So I certainly think that that's a good observation. Mark, did you have anything to add in terms of behavioural changes based on your research?
So we didn't cover that in our survey, so I wouldn't want to claim kind of empirical research, but I would say, speaking to practicing arbitrators, the big change they say is not necessarily in the actual hearing, but it's conversations around the hearing. So meeting other counsel in corridors or kind of informal discussions among clients. I think it's particularly an issue when there is some possibility of settlement, right? So in lots of cases you get, if they're big companies, for example, there may be no personal relationship to preserve, right? This is a purely contractual dispute, and so you don't lose all that much by going to a remote hearing. When there is a personal connection, a deeply personal connection between the two litigants or between the two parties, where there may be a chance of settlement if they can get over their personal grievances, I think that's what's maybe missing, which is, I suppose, is reflected in our survey to the extent that users of mediation were less in favour of online hearings because obviously that requires a kind of a more personal touch to reach settlement. So I think not necessarily in hearings in terms of behavioural changes, but behavioural changes around the hearings, not being able to have those small discussions with counsel, or how is your client feeling, or all those kind of informal discussions, I would say, around the hearing, but not necessarily in it.
Thank you, Mark. Again, you've reminded me of the situation we had once, a witness that was brought in for a Part 50 examination, and after some questioning, he started to feel quite unwell, and counsel who was cross-examining him through video couldn't see it, but the solicitors who were at the in-person hearing could. So they were the ones who eventually interjected and said, as a way of courtesy, I think we need to give him some time out to rest and pull himself together. So that's, I think, a very interesting behavioural change that you've just mentioned. Thank you. Zoe, anything from your end in terms of behavioural changes?
Yeah, I'd really endorse what Marcus just said about being cut off from informal communication. I think, that is a real loss. The chance for the parties, just through passing each other in the corridor and being civil over coffee at the break, opens up opportunities for settlement which are just absent. So I think that is actually a real loss, and that's what I called earlier the human factor. As between the tribunal and counsel, that's a different matter. I mean, I remember early on in the pandemic, we had a ridiculous submission. We had a hearing where the tribunal were actually physically present in a room in London. One of the parties was based in Paris, unable to travel, and the other party, being based in London, had booked rooms in the same building on the floor above, and the Parisians objected. They said, well, the council and the tribunal will meet in the building, and there might be opportunity for interactions. And we said, don't be ridiculous, and it went ahead. And which meant, of course, that we were absolutely paranoid. I mean, I limited myself to good morning and have you got the nice biscuits, as I recall. But that shows you how people feel very paranoid about inequality of arms if one person that is physically in the same place and the other party isn't. Anyway, and from what Janet was saying, isn't it interesting? So I mean, I think what's underscored here is the different type of user. I mean, someone in the criminal system is going to have a completely different experience. They're not experienced litigants. They may be bewildered by the process. And the idea of taking part in a criminal hearing via audio fills me with horror, actually. So it's interesting that people found it as positive as they apparently did. In my practice, we used to do some telephone hearings. We would do preliminary conferences by telephone. I think that day is gone. It wasn't satisfactory. It's very, very difficult to know when it's your cue to speak. So as a tribunal, I mean, I would actually interpose long silences just to make sure that people had finished speaking, to avoid interruptions. And I think that's gone. No one will do that now. It'll all be done by Zoom. I think it's inconceivable we'd do an audio hearing in my kind of work. Even the sort of the famous, Christmas Day injunction, not that I've ever done one of those, you'd still get the judge on Zoom. So I think we're never going back there. But obviously that, depends on what you've got available. If you just have a phone, what else can you do? I suppose this does underline a concern I have generally about inequality of access between the wealthy user and the less wealthy user. But anyway.
Thank you, Zoe. Thank you. Pardon me, it looks like I'm starting to lose my voice for some strange reason. So we've gone in swings and roundabouts as to what we think remote hearings are about, whether we think they're the future. But now I think in good old lawyer fashion, I think we need to answer the question quite directly. So do we think remote hearings are the future? Do we want them to be the future? Janet, we'll start off with you.
Okay, sure. So the use of remote hearings in the UK will always be a judicial one. So it may be that's my not being quite so direct, because it's not going to be my decision. But the plan is to roll out the bespoke platform that was being developed, is being further developed, and the plan is to roll that out so that it's available in all the courts. And it's been designed with the judiciary. It's been designed to replicate the formality of the court and tribunal building, so it looks a little bit different to a Zoom or a Skype or a Teams, and we've tried to build in some things to overcome some of the challenges. So there's a required pre-hearing equipment test. You can't join the hearing without testing your equipment first. There's a waiting room that has information about ground rules. There's also private meeting rooms have been introduced, so that for discussion and deliberation. These are things that were not there during the pandemic, so our research doesn't reflect these things being in place, but since then they have been developed. There's also conjoined rooms for simultaneous interpretation, and there's been a new role within HMCTS, so a video hearings officer that will support remote hearings as they're running. So that's a new type of role. So staff are flexing to prepare for the delivery of remote hearings, and the aim is to provide the option for remote hearings, to give flexibility and access, and also some of those hearings will be hybrid, as I've already talked about, and some of them will be remote, but it's just an option for judges should they wish to go down that route.
Thank you, Janet. Mark, what are your views?
Yeah, I think I'm going to have to be the typically hedging academic and say it depends, right? So it depends, firstly, what types of disputes, and then secondly, what types of hearings. For disputes, some of the factors that were raised in our survey, I think, are going to be significant. So the value, I think, is probably going to be the most significant one. If you're in a case where the dispute is over hundreds of millions of dollars, it seems inadequate to not meet in person when you can, which seems to concede to some extent that the online hearings are suboptimal when compared to in-person hearings. But I think even proponents of in-person hearings would probably concede that it is better, particularly when you have complex witnesses, complex cases, lots of evidence, that you meet in person. But for things like criminal disputes that were raised in Janet's study that were not considered in our study, it seems too serious to have that online. The idea of being sentenced to a long-term prison sentence online seems not quite right. I'm not sure I can articulate it in any more of a professional way than that, but it seems unjust in some way to be sentenced online without that person. I think that the sense of legitimacy in the criminal justice system will demand a return to in-person hearings for serious cases. For commercial cases, I think if they're of low value, where cost is important, flying counsel from one continent to another and flying everyone all over the place, putting them up in hotels, etc. I think remote hearings may become more commonplace because of the costs involved, because of the costs in comparison to the value of the dispute. It's just more economical to do that online than in person. So that's the kind of disputes I think that might be amenable to online or remote hearings when compared to in person. In terms of in-person hearings, so recently Singapore has become quite a proponent of mediation. They've recently signed a mediation convention. I think for mediation proceedings, it's just more optimal to have it in person for all of the reasons that Zoe outlined about these informal conversations you have at before the hearing and at breakfast and afternoon and all that kind of stuff. And when you're attempting to seek settlement, when that settlement will not be reached unless the two parties find a way to overcome their obstacles, it's just better to do that in person than it is to do it over Zoom. So I think for mediation proceedings or proceedings that are more consensual or alternative dispute resolution mechanisms, I think we'll return to in-person more frequently. For arbitration, I think they're more flexible because it will depend on the parties, right? Because the parties get to design the process, it will be up to the parties. So if it's a high value dispute, then they may prefer in person, but if it's a lower value dispute, then they may be content with online. So my typical academic answer is it depends, and it depends on the type of the dispute and on the type of hearing.
Thank you, Mark. So I guess I'm hearing cost-benefit analysis is key in a way. You've got to measure it all up and see what balances out. Zoe, you've already told us what your answer is.
Yes, I have.
Anything you wish to add? Which is that you think that to some extent the future is remote hearings.
Absolutely.
Yeah.
Very much so. In commercial disputes, and particularly for a court like the DIFC court, which is intended to be an international court. And frankly, even in London, where it's in the gift of the court, not of the parties, a lot of hearings will remain online. For example, in the commercial court in London, the judges only hear trials and big actions Monday to Thursday. Fridays have always been set aside for what we quaintly used to call summonses, but are basically essentially 2 hours or less interim applications. And they've already indicated that for the foreseeable future, I quote, those will remain online. And that's obviously appropriate. Having said that, a lot of other interims, the more complex interim cases, are going back to in person in the courts. Arbitration, it's in the gift of the parties. It seems to me that the division is going to be that I've outlined, which is that preliminary matters involving counsel arguments will be online, and that the parties probably will prefer to have in-person hearings for witnesses. Subject, there's always one witness who lives too far away or can't travel for whatever reason. But I think they're here to stay. It will now be a significant proportion of my practice. I expect to be online for the foreseeable future, and frankly, I'm happy with that.
Thank you very much. Thank you very much. I think we've had some wonderful insights. Certainly, something for me to go back to in terms of registry practices. So thank you very much, Mark, Janet, Zoe. Have a wonderful day, and I hope to see you soon.
Thank you.
Thank you.
Thank you.